This is Brown County case number 19 CF 1630, State of Wisconsin versus Christopher Sean Butler. The state is here by District Attorney David Lassay. Attorney Chris Hartley is here. Mr. Butler is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. We are on the calendar today for a final conference. I believe two issues discussed at the last hearing that we were going to address today was the necessity of the GPS requirement and the February 10th jury trial date that we have in the case. Let me go to the state first. At the last hearing, it was asserted that he is on probation and parole and he has a GPS device through DOC doing the same thing. And I asked the state if they were able to confirm that. Was the state able to or not?
I think that we were able to confirm with the agent that they likely could include exclusion zones of the crime victims on that GPS device if the crime victims are willing to share that information and we share that with DOC, if that's okay. the issue or the concern that the court had.
And the device that he has for as a condition of bond, does he have exclusion zones right now on that device? Do you know?
I think so.
That's my understanding too, Judge.
Okay.
I think DOC indicated they could essentially accomplish the same thing. So I don't think there's a need for there to be a duplicate. I mean, as long as DOC has the GPS device on it and that we still can accomplish the same thing, then I'm comfortable with that. We would have to certainly work with DOC to ensure that the monitoring is as stringent or as frequent as the current bond condition. I don't see why it wouldn't, frankly. I mean, DOC has the ability to incarcerate if there's a violation immediately. So,
okay. So if we can get confirmation from the probation agent that they have included those exclusion zones on their device, and there's a stipulation, and the parties want to submit a stipulation for me to sign to remove that condition from the bond requirement, I would sign that then. And then let's move to the jury trial date for February 10th. At the last hearing, Attorney Hartley, noting that his client is no longer in custody after posting a significant cash bond, was asking for additional time to prepare for the trial and asking for a new trial date. And then I gave the DA's office time to attempt to talk to the victim on the case about that request. DA Lassay.
Your Honor, it is the desire of the crime victims that we proceed with the trial as scheduled. So on their behalf, I would request that we do so.
Okay. I'll go back to you then, Attorney Hartley, if you want to supplement any your requests for an adjournment.
Well, Judge, I'll tell you that some additional things have sort of developed since we were last on the record a few days ago. I guess I'll start with number one. 2 days ago, the Wisconsin Court of Appeals came down with a decision, and I hastily filed a motion to dismiss this afternoon, although when I look at the hard copy, I e-filed it, but I think the case number is incorrect, so it'll probably get rejected. But 2 days ago, the Wisconsin Court of Appeals rendered a decision indicating that the circuit court in Marathon County on a case lost personal jurisdiction over a defendant because they failed to provide him with a timely preliminary hearing. The preliminary hearing in that case was delayed for, I believe, 113 days because the Office of the State Public Defender was unable to appoint counsel for that defendant. In our case with Mr. Butler, as you know, Mr. Butler was in custody for a very substantial period of time. By my calculation, he was in custody 343 days before he was afforded the preliminary hearing for the same reason as the Marathon County case. That is a failure of the public defender's office to appoint counsel at no fault of the defendants. That case again came down 2 days ago. My very brilliant associate attorney came across it this morning and brought it to my attention. It's a fairly lengthy case. I had the opportunity this afternoon to read the case and cobble together a motion to dismiss, which again has been e-filed this afternoon. But I think we're going to need to address that ultimately at some point, because it's our contention, for the same reasons in that case, that this court has lost personal jurisdiction over Mr. Butler for the untimely allowance of his preliminary hearing. And I know that this is all coming up at the last minute, but that case again was rendered 2 days ago by the Wisconsin Court of Appeals. So that's number one. Number two, I have a doctor's appointment on Wednesday wherein my surgeon is going to tell me hopefully what day we're going to have rotator cuff surgery on my right shoulder. I've been having physical therapy for the last 6 weeks to try to rectify the torn rotator cuff, but honestly, it's just not working, and I'm frankly unable to sleep most nights. And so I have that consultation on Wednesday, and he's going to tell me what day, hopefully in February. I don't have the date yet. I'll do my best to try to accommodate all of my cases, but if I'm given a date that interferes with this trial, I'm sort of going to be conflicted for that reason. But I wanted to let you know that that was a competing consideration. So those are the things that come to my mind, Judge. I'll tell you that I was appointed on this case, as you know, sometime in September. Mr. Butler had a preliminary hearing at the end of September. We've only really had the discovery for about 3 months. Mr. Butler's penalties are very, very significant, including the possibility of life without parole. And honestly, given the pandemic and the fact that we're about 3 weeks away from trial, I know initially Mr. Butler asked me to file a speedy trial demand, which I did because that was his request, but I don't think it's necessary anymore. And I'm still not thrilled necessarily with trying this case in the global pandemic that we have, if it's not necessary, at least from our perspective. I can appreciate the victim's wishes, but we have to balance those against other people's rights as well. So those are my thoughts, Judge.
Thank you. Are you available again next Friday at any time for a Zoom hearing?
Yes, I would say probably it would be late morning or any time in the afternoon.
How about 3 o'clock?
That's fine.
And if the victim representative is not available at that time, now would be the time to tell the court so that we can pick a different time?
Your Honor, I'll make myself available. I don't know if I have an opportunity to speak today or not.
Yes, you do. I am going to keep the trial date on and review the motion that was filed. That's why I'm having the quick turnaround again for next Friday. If there's any other comment you'd like to make, you are certainly free to.
My understanding in working with Erica, who works with the victims, I can't tell you how many written communications I've had regarding preliminary hearings on Mr. Butler. Charges were filed back in October of 2019. So we're quite a ways into this. in my understanding, at least what was reported to me through Erica, is that, many public defenders were appointed and Mr. Butler chose to keep kind of churning through them and trying to push this through quickly. So it's just interesting to me that, over a year later, now that he's been able to post bond and he's got some freedoms back, at least temporarily, that now all of a sudden we seem like we need a lot more time. So it's just my opinion, my observation.
Thank you.
I'm the grandmother of the girls.
Thank you. Do either of the lawyers know if that case is, it sounded like that was a Court of Appeals case, if that was going to be appealed to the Supreme Court? Is that even
Not
out
sure.
yet?
I'm not sure yet. It was just rendered 2 days ago.
Not sure. Yeah, it is a new decision. We're certainly well aware of it. I think there are some differences in that Mr. Butler here, I mean, the practice in Brown County is to engage in balance of initial appearance rather than have the preliminary hearing set over. So that is a significant difference from the state's perspective here, is that the initial appearance was not completed, which didn't trigger the 10-day time limit. I also would note that that case was dismissed without prejudice, as would be done. So again, if the situation here involved a dismissal, it'd be a dismissal without prejudice, free to recharge. We'd be back in the same position with a more significant delay. So, the practical effects of that are essentially nil, just that the case would have to start over. We'd be right back where we were the day that we held Mr. Butler's preliminary hearing. So, I appreciate that is the Court of Appeals decision, but the practical outcome of that is sort of nonsensical. When you read that in conjunction with reality, is that if every case ended up being a dismissal with a subsequent reissuance when there's an attorney, then you'd never find an attorney. So the Court of Appeals really created a sort of an untenable situation, because you're never going to find an attorney for a defendant when a case isn't filed. So I don't know. Those are my personal thoughts after having reviewed that case, and obviously the court will have to conduct its own review based on the motion that's been filed.
And when you filed the motion, did you include a copy of the case or a citation? So I can
I
find it.
included a citation, but it's probably going to get kicked back because of the wrong case number. I'll correct the case number. I'll refile it, and I'll include a copy of the decision.
Okay, because if it's brand new, it might be difficult to find.
Your Honor, if you don't mind, I mean, I'm willing to email a copy to the court and to Attorney Hartley of the case, so that both of you have that, and that it's not an ex parte conversation. I actually emailed a copy of that decision to Judge Hawk, who's the presiding judge in Brown County, earlier this week when we got it, just because I think it is an interesting case that does have a potential impact, and all of us need to look at that and consider the practical effects of that decision.
Okay, thank you.
I'm fine if the state wants to directly email it to you, Judge.
Okay. Then we'll be back on Friday, January 29th at 3 o'clock, and the scheduling remains the same, and we'll address it again next week. Anything additional from the state?
I would just ask, Your Honor, I believe there was a filing deadline for the state to provide its list of witnesses and jury instructions. I would ask if we could file those by Monday. I think the deadline was today. I would just ask that we could do it Monday. Attorney Saunders was the attorney of record on this case. He left the office this afternoon to have a COVID test. I will be the attorney that's handling this case if it does go to trial on the date that it's currently scheduled. So I'll make sure that it gets filed by Monday at the latest.
Judge, I joined that request and I have no objection.
Okay.
Because I think it's the same for both parties, and my afternoon was consumed with this new case that came down, so.
Okay.
Yeah.
I'll just say file those documents by Friday, January 29th, by next week's hearing.
Thank you.
And then bond continues, and I'll remind you again, Mr. Butler, you have a significant cash bond that you posted in this case. So make sure you follow all the conditions of bond, or the statute says bond shall be forfeited. Okay.
Okay, so I can get this removed, or still have to?
Your lawyer is going to contact the probation agent, I would assume, and when you get confirmation that the probation device is doing the exclusionary zones, the same thing that the bond GPS is doing, and makes them two devices doing the same thing, then the bond one can be removed.
So do I have to go back in front of you before I know that, or my attorney can let me know that?
If the attorneys file a stipulation with the court, I'll sign the stipulation.
Okay.
But otherwise, if they can't get the stipulation filed in time, we can address it a week from today also, if that gets accomplished.
All right. All right, appreciate it.
Okay, then bond continues, and that's all for today. Thank you.